Madam Chief Justice, Associate Justices, Counsel, may it please the Court. The matter before you today, as you know, but by way of a brief recap, deals with the constitutionality of a supervisory order that extended the statute of limitation in civil cases here in Iowa in lieu of the COVID pandemic. The case at issue is a personal injury case with an initial date of loss of August 4th of 2018. So typically with the 2-year statute of limitation, August 4th of 2020 would have been the due date for that petition to be filed. However, due to the COVID pandemic, the Supreme Court issued supervisory orders beginning in April of 20 that included, of point here, an extension of the statute of limitation by 76 days on civil cases such as Ms. Rivas's. Ultimately, the petition was filed after August 4th, which would have been the normal 2 years, but before the 76-day extension. So it fell right in that window that was granted in the supervisory order. And as far as the timing, there's no issue or arguments about that. This is really turned as, this is a separation of powers case. And there are some, of course, some other angles, but I'll lead with separation of powers because it seems to me that if this court determines that separation of powers was not violated, the rest of the arguments herein are moot. So looking first, we cited the case of State v. Thompson. Now, interestingly, in Thompson, that dealt with supervisory order that made a change to it dealt with a statute that prohibited pro se filings. So in that case, it was a legislative action that was kind of coming over into the judicial, whereas opposed to here we have, so this is an inverse case, but the court's reasoning in Thompson is exactly right on, and it still applies here. What happened is the court in Thompson found that this statute that discussed this filing was absolutely acceptable and not a violation of the separation of powers because, in short, the code section did not impede the immediate, necessary, efficient, or basic functioning of the appellate court. So just as a supervisory order at issue in Rivas, which in no way impeded anything, and in fact, if anything, it assisted the legislative branch. Yes, certainly.
If the legislature had wanted to extend the statute of limitations, could it have done so?
Certainly, at any time. And I think that that's one of the very issues, and that's what the Appellee's, one of their positions is, well, look, the legislator previously acted, therefore, in their position, that essentially they're the only ones that can ever act again relative to that issue because of the statute of limitation statute. However, what is completely overlooked in that, sure, did they act way back when? Absolutely. But then we have a global pandemic, lives, businesses, court procedures, everything around the entire world changes, and it was so concerning to the Iowa legislature that they just suspended their session and went home. So then Governor Reynolds, 2 days after that, issues her proclamation about the global emergency. So now everybody really knows that everything is changing. The legislature did nothing. They did not act relative to statutes of limitations in lieu of a worldwide pandemic. So essentially, they forced the judiciary to act, and with the power granted to the judiciary under the Iowa Constitution, the Supreme Court was forced to act because the legislature did not act.
Well, maybe that is their action. I mean, when the legislature leaves, do they have to enact a bill that says, by the way, all of the laws that are currently in the code are still in effect, and you should enforce them? I mean, that's kind of your argument, is they left, and because they didn't say anything, then we should assume that everyone's just free to change the law.
I disagree, and that is not my argument. My argument is, it's, to me, obvious plain on its face that action had to be taken relative to the statute of limitation, evidenced by the supervisory order that extended the statutes of limitation. So without legislature around to even know what was going on, I mean, the flip side of your question would be to imply, well, if the legislature already ruled on something, then nothing can ever be done because they chose not to do it. We were in a position, the world and the state of Iowa.
That is right. The lawmaking power is vested in the legislature, and if they pass a statute, then it's law until it's repealed. I mean, that is what Article 3 says.
Iowa Supreme Court retains inherent power through the Constitution to make changes. Yes.
Tomorrow issue a supervisory order tolling the statute of limitations for the rest of the year.
Supreme Court?
Could we tomorrow just toll the statute of limitations?
And I'm not trying to be cute, Your Honor, but that would be a two-pronged question because certainly you could issue a supervisory order. The question would be, would it be constitutional or valid? You know, so yes.
Constitutionally, could the court issue an order tomorrow tolling the statute of limitations?
A valid one? Yes.
And under what authority?
Under the authority via the Iowa Constitution, Article 4, Section 4. And if I can expound on that a little bit more, because that power is actually a two-pronged power. So for clarity, Article 4, Section 4, the Supreme Court shall have power to issue all writs and process necessary to secure justice to parties, comma, and shall exercise the supervisory and administrative control over the inferior judicial tribunals. Throughout these arguments in the briefs, the focus has been on the second half of that clause. The Iowa Supreme Court has the power to issue all process necessary to secure justice to parties. So based on that, could the Supreme Court issue a valid supervisory order tomorrow? I believe so.
So we have a lot of certificate of merit cases in the medical malpractice context. Could the court constitutionally say, through supervisory order, we find on the ground that this statute creates a lot of injustices and that cases are dismissed. And under our supervisory powers, we are hereby tolling the certificate of merit requirements for 180 days in every case in the interest of justice. Is that a permissible exercise of this court's supervisory authority?
I believe it is. So back in State v. Thompson, where it picks up on that again, Your Honor, the supervisory order is not impeding anything, and again, in fact, it was an assist to the legislature. The Thompson court then really summed up, when you're looking at separation of powers, they summed it up. Stated differently, one department of the government cannot impair another in the performance of its constitutional duties. So again, the supervisory order that's at issue here today, that was issued because the legislature wasn't in session and we were in a worldwide pandemic, did not impair anything.
Could you speak to the practical need for this extension, including that a lawyer couldn't meet with a doctor to evaluate a personal injury case? Your offices were closed, things like that.
Right, that's correct, Your Honor, and it seems to me through my readings, and it's that the court was acknowledging the challenges with, and again, and I want to say some of this, whether it was real in fact or belief because of misinformation or whatever we were all believing, during these early days of COVID. I'm not going to say, I can't say specifically, Miss Rivas this, Miss Rivas that. Because I don't recall specifically. I can tell you that it was very, very difficult to see clients in person. Many of my clients also are worse at tech than I am, meaning Zoom was very difficult, right? You want to talk about, and since IMEs were referenced quite a bit this morning, to try to get IMEs scheduled, to try to, get discovery, even get with other counsel, because as the court knows, some of us, our offices were open, some of them weren't. It was, as it was for the rest of the world, not saying we had it any worse, it was a disaster doing, yes.
Have needed to do all of those things to be able to file a petition in this case?
Your Honor, and in this case, I can tell you that at the time this, that the statute was running, Ms. Rivas was still treating, and we were in that window, as often happens in the world of personal injury. Might get it done, might get it done. If she gets her treatment done, hey, there's this extra 76 days. Let's see if we can, get this done before it has to go into suit.
Heard about any of that? About the process that was used by your office or Ms. Rivas's healing, right?
Within the record, Your Honor. Okay. I'm sorry, Your Honor, had you finished your thought?
I'm not sure why that necessarily prevented you from filing the petition.
Well, when you're putting together the petition, you need to know, really the full extent of injuries, so that you you can actually you can correctly put in your PEXA numbers, and whatnot.
It doesn't need. I mean, you might prefer it to, but it doesn't need to. Is there anything in the record that shows that your office relied on her supervisory order?
Other than I'm the attorney of record and I relied on the supervisory order, do I have that elsewhere in any kind of writings or process in my office? No, I don't.
Counsel, the Constitution was amended in 1962. It previously provided the court with supervisory control. It added the word administrative control. What's the distinction between those two words, in your view?
If I could take a moment, Your Honor, I do have that addressed. One, I can mention that does tie into the temporary changes, which were also cited in some of the cases within my brief. And as the court put within the supervisory order, these temporary changes that they're making. Your Honor, can I tell you specifically the specific difference between those two in this context? I cannot. It's that I don't want to try and misspeak on that.
Reasonable for Iowa lawyers to rely on an extension granted by the Iowa Supreme Court?
Is eminently reasonable for a practitioner to rely on the guidance of the Iowa Supreme Court. Yes, Your Honor, I do. As the court has ruled on a very similar case, the State v. Basquin. Now, the distinguishing feature in Basquin, it was a supervisory order change to a criminal plea is what it was. So, the appellees are kind of contending, well, that didn't have anything to do with a statute, right? That was a rule, and so therefore Basquin doesn't apply here. That said, reading what the court held in Basquin that I think is most pertinent here, again, I already referenced that the Iowa Supreme Court noted that these were temporary procedural measures in response to the global pandemic, to which we already know the legislature did not act in that vein. And then very interestingly,
about that? I thought the legislature did reconvene briefly and they actually passed a statute during the pandemic.
Not prior to the supervisory order that the Supreme Court issued that led us here today. And Your Honor, I'm looking just specifically at the supervisory order that I relied on. Once anything that changed, my client was still in that window of time. So it's not anything that I addressed or, in my opinion, comes into play today.
I understand the reliance argument, and it's compelling. I think it's, in my view, probably the most compelling argument you're advancing. But how do you address, or will you address, the case law that indicates parties cannot rely on what ultimately turns out to be unconstitutional laws of any type, whether they're statutes, regulations, orders? And I think the law is fairly clear on that. I think the U.S. Supreme Court's actually decided a case that involved reliance on an extended statute of limitations that was ultimately held unconstitutional So address that issue for me.
And Your Honor, I didn't catch the specific question in there. Mm-hmm.
If there's a body of case law that says, despite maybe the equities in the particular case, that still says parties cannot have valid legal reliance on laws that are ultimately held unconstitutional, what is your response to that?
My first response is that your supervisory order was not unconstitutional, so it's a moot question. Secondly, I would contend I did not see any said cases in the record submitted by the appellees. And thirdly, I don't disagree with that. If there's reliance on something that turns out to be unconstitutional, then I guess suppose that's the risk of the practitioner in that. But in this case, again, supervisory order was not unconstitutional. Even interestingly, in the language back to the separation of powers, the last half of the quote from Basquin states, "We likewise did not use any power granted exclusively to another branch of the government." That is the on point from Thompson. One of the big factors to be considered whether separation of powers was violated. So the Iowa Supreme Court, in their own supervisory order, notes it's temporary, notes we didn't borrow anything from the government, and we also know that the legislature failed to act in light of the pandemic.
We still had some time. It's red light. Do you want to? You'll get to come back. It grows, and then it starts to grow. It's confusing to all of us.
For right now, Your Honor.
But sorry about that. Okay. And now we're going to hear from, let's see here. Mr. Leverenz. Thank you.
May it please the court, counsel. In Harrington versus Toshiba Machine Company, this court dealt with a case involving products liability and the statutory framework provided for the tolling of the products liability statute. Direct and on point to this particular case, the Harrington court stated, in the present case, the plaintiffs were left with only 2 days to file the suit following identification of the manufacturer. However, 2 observations must be made. First, the tolling of a statute of limitations is purely statutory, and we are not free to expand the concept to avoid hardships.
We do toll statutes of limitations on non-statutory grounds. There's equitable estoppel. There are things like that that are not in the Iowa Code. Am I not correct?
Equitable tolling is an argument for several umbrellas that discuss the when a claim accrues under 614.1. For example, the discovery rule. The discovery rule doesn't actually pause or extend the statute of limitations. The
discovery rule is different. Let me give you a hypothetical. If on August 4, 2020, Mr. Johnston was headed to his computer to file this petition in this case, and you blocked him or you hacked his computer so he couldn't do it, we would say the statute of limitations is excused, and you wouldn't oppose that, right?
Your Honor, and that would be something that was discussed in Skadberg versus Gately, where it discusses the different types of equitable tolling. For example, the discovery rule. And what Your Honor is referencing is the fraudulent concealment rule, where the defendant takes some affirmative act to prevent the claimant from filing on time. But again, that particular legal theory has more.
Let's say on August 4th, 2020, our whole EDMS computer system crashed. Courthouses were open, but our EDMS computer system crashed, and he couldn't file his case. And we said, we're tolling the statute of limitations by so many days until the crash is up and running and things are back to normal. Would that be constitutional?
Not without legislative process, whether it's by submitting through the power granted to the court to prescribe rules, for example, Iowa court rules of civil procedure, criminal procedure, appellate procedure, that actually through 602.4201, 4202, or 2.42 subsection 13, which is the interplay between this court and the legislature about adopting Iowa court rules. For example, there's in the Iowa court rules of civil procedure, there's a tolling provision for class action lawsuits, and while those are a different animal altogether, that rule went through the legislative process of being submitted to the legislative council.
Does the court have any emergency powers, either under the supervisory or admin powers that it holds?
29C, in dealing specifically with the declaration of an emergency by the governor, discusses the different powers that are provided to the different bodies of government. For example, 29.
That's the extent of the emergency powers that this court has?
Dealing with the declaration of an emergency by a governor, 29C is the power that's at issue in this particular case. Subsection 3 deals with the powers, additional powers granted to the governor, for example, prohibiting people in public places, and 29C.4 is the provision that addresses the powers for the Supreme Court, and it is specifically addressing, in that case, protecting the constitutional rights of persons in custody, which very much interplays with the Baskin case, dealing with an individual who was a defendant in a criminal action, and the reason why in Baskin the court changed the rule, not a statute, changed the rule of criminal procedure about pleading for felonies in person versus being able to do it in writing, as was provided by the supervisory order. In Baskin, the court had that power by 29C.4 because it dealt with the persons in custody and the court's ability to alter requirement of being in person to writing to protect the rights of people in custody by this court. That's the additional power that's granted to this court under the governor's supervisory order declaring a state of emergency, but there's no power granted to this court to change the statute of limitations that's prescribed by the legislature.
Is there anything in the record that would help us look at this question of whether or not our order sort of prevented the plaintiff from timely filing, or was otherwise a hindrance in the way that an EDMS shutdown might?
No, Your Honor. That was never a part of the record, and that kind of ties into the idea of equitable tolling. That's one of the arguments that the appellant is making in this case, that even if the court determines that it was unconstitutional to extend the statute of limitations, that it should be equitably tolled. And first and foremost, the equitable tolling was not even raised at the district court level. There was no fact finding in regard to that. So no, there is no evidence on the record, and in fact, it shouldn't even be considered by this court, given that the district court never had a chance to actually even address the equitable tolling argument made by plaintiff. It was brought for the first time on this appeal, which is not allowed. But going more to the equitable tolling argument just on its merits, discussing earlier, equitable tolling, discovery rule, whether it's the malfeasance rule of a defendant or a continuous representation rule, the equitable tolling in those particular legal theories is not about let's add to the statute of limitations or pausing it. It's about this court's inherent power to interpret statutes, and that's what it's doing under 614.1, is interpreting when a claim accrues. For example, in a medical malpractice case, you're looking at the discovery rule about when the claimant knew what and when, and that's the implementation of the discovery rule of when did they know, and that's when we're going to start the tolling of the statute of limitations.
About the Michigan case, Carter, that came down July 29th. Are you familiar with that case? Okay.
Really kind of the same issue as here. So Michigan, go ahead.
I was going to ask you a question about it, but if you haven't read it, that's fine. Okay.
Oh, I'm sorry, Your Honor, I wouldn't be able to address that. Going back to the Thompson case, the Baskin case, as well as the Root versus Tooney case, what those cases discuss and don't dispute is that the legislature has the constitutional authority to regulate practice and procedure in the Iowa courts. And understandably, the statute of limitations is a procedural aspect, it's not jurisdictional. However, those cases also all state that when the legislature has spoken on a specific topic, the judiciary has to give way to that. And here we have the legislature who specifically discussed the topic of the statute of limitations, 2 years for a personal injury lawsuit. And I think there's important information not only from the majority of Thompson, but there's also important information from the dissent of the Thompson case as well, because the dissent in the Thompson case didn't actually, from my review of it, didn't actually disagree with the majority's interpretation of the interplay between the judiciary and the legislature in the passing of the Iowa court rules. But what the dissent felt and took umbrage with in the majority is that it felt that the statute in the Thompson case interfered with this court's ability to oversee cases and controversies before it. That the statute that prohibited this court from being able to review pro se briefs when that defendant was represented prevented this court from doing its constitutional job of overseeing cases and controversies. And so the dissent, well, that's the reason why they dissented from my review of the case, is because they felt that that statute was a violation of the separation of powers, because the legislature had made an act that limited this court in its ability to oversee cases and controversies through the statute that didn't allow representative defendants to file pro se briefs. But what?
Tony, the supervisory order that was challenged shortened the time allowed to file suit, and the statute had provided for 30 days, and this cut it short. And today we're talking about giving more time for litigants to have access to the court, not less.
I don't believe the Root versus Tooney case was simply about just shortening the 30-day time period in which to it was about you can't change it because the legislature has set it for 30 days, and it was addressing the supervisory order that had basically said that that the district court clerk's offices were going to be hours were going to be shortened because of budget constraints, and that it stated but this provision, given the extra 1 day, won't apply. And what the court disagreed with in my reading of the majority opinion is that you can't change that 30 days. You can't, by a supervisory order, go in and say this additional 1 day won't apply. The legislature has spoken on the 30 days. There's a rule in there about when the clerk's office closes because of a supervisory order, you get an extra day, and that the court wasn't going to change it, and that's what that case had determined.
First of all, life has a way of passage of time. It has healing, and I think enough time has transpired since COVID that we have gotten a little bit more comfortable and maybe feel like we're kind of getting back to normal. But I want to take you back in time when this order was entered. It was not a normal order by any means. I think everyone would agree, and I challenge you to think of any time in the history of the state of Iowa that jury trials were shut down, that an extension was made for statute of limitations. But I just want you I wanted to draw attention to the actual order that we've been talking about. It was entered, and it referred to our authority under Article 3, Section 1, and Article 5, Section 1. But I think this paragraph is really important. The judicial branch gratefully acknowledges the information and feedback provided by the Iowa State Association of Counties, University of Iowa College of Public Health, Iowa State Bar Association, Jumpstart Jury Task Force, Criminal Rules Revision Task Force, Iowa Department of Human Services, Iowa Department of Public Health, and the dedicated employees of the judicial branch, all other attorneys and Iowans who have contributed their thoughts and suggestions. Not to say that little window, that 76, I mean, it's a weird number. We didn't just pull it out of the air. It's a number that the governor of the state of Iowa, that's the number of days that there was a shutdown. Does somebody really need to try and prove why they couldn't get their stuff together? Maybe they were taking care of their family, whatever it may be. This is not a normal analysis of why didn't you just go to the courthouse or file it. There's got to be an acknowledgement. This was incredibly unusual. And do you have any authority of something the Iowa Supreme Court has done before to make it appear as if we're taking advantage of our inherent authority?
Well, my response to that, Your Honor, would be this case and appeal is not about whether the court's reasoning behind the extension was appropriate or not, or whether it was justified. But this case is about whether taking that action of extending the statute of limitations was beyond its power, because the statute of limitations is inherently a statutory act that was passed by the legislature. And that's why I started this argument off by citing to the Harrington case that discusses statute of limitations, and that any tolling of the statute is strictly statutory, and that that this court is not free to expand the statute of limitations to avoid hardships, which is an important and on-point issue when we're dealing with a case like this. Is that I'm not going to come up here and deny or argue about what personal injury offices could or could not do with their clients. That information is not in the record. The equitable tolling argument should not even be addressed because it wasn't addressed at the Supreme Court level. This appeal is about a specific provision in that supervisory order about the tolling of the statute of limitations, and whether that in of itself is something that this court has the power and authority to do. And the position of the appellee is that it does not. In looking to the Root versus Tooney case, the court in deciding that stated, in any event, the supervisory order cannot trump the General Assembly's authority to set the time to file a notice of appeal. And I understand that in that sentence they're dealing with the notice of appeal, which is more of a jurisdictional issue. But in this particular case, the statute of limitations is a procedural issue. And as Thompson, Basquin, and the other cases all state, is that the legislature has the constitutional authority to regulate both practice and procedure. And
authority, it's not exclusive to the legislature. We run the court system. And didn't we, in Baskin, the majority opinion noted that the legislature had not acted to rescind our temporary rule, right?
That was noted, but I don't think whether the legislature did or did not act following the COVID supervisory order should play any impact on this case, because the legislature already spoke when it acted the 2-year personal injury statute. And
Justice McDonald's memory and mine as well, accurate that the legislature did reconvene in the summer of 2020, although briefly, and did enact something?
Your memory might be better than mine, Justice Waterman. I don't.
They would have had the opportunity, if they disagreed with our supervisory order, to pass an enactment rescinding it, and they did not, just as they took no action to change what we did in Basquin.
Honor, but if that indeed occurred, I mean, it's a double-edged sword, because while they could have stated that was wrong, they also could have said, as we agree with the court and we think there should be an appropriate extension of the statute of limitations given our statutory power to regulate the court's power and the procedures of the court, including the statute of limitations. So I understand my time's up. Could I just have 30 quick seconds unless there's any other questions?
Questions first, but you can briefly wrap up.
Just in conclusion, Your Honor, I was talking about the quote from the Root versus Tooney case, but you can easily exchange out personal injury lawsuit for notice of appeal, and stating that in any event, the supervisory order cannot trump the General Assembly's authority to set the time to file a personal injury lawsuit. The Harrington case that I cited to start is still good and valid law. The Root v. Tooney quote I just gave you is the majority good and valid law. The Thompson case, both from the majority and from the dissent, regarding the legislative power to control the procedures of this court, which is exactly what the statute of limitations is. It's a statutory procedure, and this court, through a supervisory order, cannot extend it. Thank you very much, Your Honors.
Back to Mr. Johnston.
Thank you. I did want to also go back to Basquin for just a moment, so glad it stayed here. One thing when I read previously about the part of the court's holding that I thought most relevant to what we're dealing with here, I failed to put proper emphasis on one letter, because in Basquin, the court held our COVID-19 supervisory orders providing for temporary procedure, et cetera. So the court has already determined that its supervisory orders, again, plural, fell well within the grant of constitutional authority dedicated to the judicial branch. So as I read it, the issue is already decided in reference to the multiple orders of which we're dealing with here. On root, interesting thing about root, yeah, and it was about the clerk's court being, closed and then the application of the statute. However, logic tells us if the Supreme Court can close the clerk's office, which is automatically going to change the statute of limitation date, then the court logically retains the power to change the statute of limitation. That's how I read root, and I think that's what applies here. As the court mentioned, during this session and when the legislature came back, no action was taken. It's as though the legislature then, just as I did, relied upon the supervisory order because they took no action to do anything otherwise with it. And I do want to touch on due process, of course, hugely important, but in this particular scenario, we can apply a balancing test. The appellees, it's an affirmative defense that they can actually waive and is waived the statute. They haven't been prejudiced. Nothing changed. The injuries didn't change. Discovery isn't going to change. So they have a waivable interest. The appellant, on the other hand, who relied on the supervisory order, she's got nothing. If the court finds that the supervisory order at issue was unconstitutional, Marlene Rivas, in reliance on the Supreme Court supervisory order, will be out. And that it just simply isn't right. So weighing the due process, which, once in a while, does something go and we can kind of see it and somebody gives up something? Yeah, it happens. But it's my position that it's the citizens of Iowa shouldn't be the ones that take that one on the chin.
Case of conflict. And let's assume that the legislature, before leaving during the COVID pandemic, said that statute of limitations shall remain in place. And the court decided that given what was going on, that would not be appropriate, and then issued the supervisory order. What is the result in that case? Who prevails?
I think the Iowa Supreme Court prevails. Because it wouldn't, to me, it would be no different if they made a statute right before they bailed versus when they, actually came up with the statute of limitation.
Legislature specifically said the statute of limitations shall remain in place. It's your position that this court would have constitutional authority to disregard that if we thought the circumstances demanded it.
Circumstances indicated, yes, absolutely.
After we entered the supervisory order, could the legislature override it then? Could they have disavowed it and said the supervisory order with respect to the statute of limitations is invalid and we're going to reject it?
Well, again, I suppose anybody can do anything. The question is, what the resolution of it would be.
If the legislature came back and said, we're going to strike that part of the supervisory order, statute of limitations are not subject to a 76-day tolling, who prevails in that separation of powers fight?
I think the Supreme Court, because obviously, make an example, there's going to be a lag between the supervisory order and the legislature. So let's say it's even a week, all right? There's still going to be somebody that falls in that window of time, that week, and for that person that fell in that window of time before the legislature said it's no good, that person should still have the rights, and the Supreme Court's supervisory order would still be valid for that window that they did it.
Kind of pin down do we have shared authority? I think that's what this really comes down to. Does the judiciary and the legislature have shared authority to determine what the statute of limitations is, or because it's a statute, is that solely within the legislature's prerogative?
Based on circumstance, it's a shared authority. In a situation like this, you're granted power by the Constitution. It's a temporary change because something is different. So yes, in that regard, exactly where we are today, the Supreme Court has shared authority with the legislature to do exactly what happened.
Apply to criminal statute of limitations as well.
Is a non-criminal practitioner, a bit of a stretch, but I believe that it would. The powers of the court remain the same, the documents remain the same, the timing remains the same, so civil or criminal, I would contend yes. And if no further questions, I would ask that the case be reversed and remanded.
Mr. Johnston, the case of Rivas versus Brownell and Wessel is hereby submitted, and the court is going to take a morning recess before afternoon arguments. Thank you.